I wish to bring to Honourable Speaker's notice a breach of privileges and powers of Parliament arising from the interim orders made on Friday 3rd March 2023 in the Supreme Court of Case SCFR Application 69/2023. The Parliament has the power to act when there is a violation of its powers and privileges arises from Article 4C of the Constitution. Article 148, 149 and 150 of the Constitution vests the Parliament with the full control over the public finance, including the consolidated fund. Secondly, monies from the consolidated fund can only be withdrawn under the warrant signed by the Minister of Finance. Thirdly, the warrant can be issued only if the money is voted by the Parliament for a specific public purpose. The Parliament by Appropriation Act number 43 of 2022 has allocated monies for the activities of the government for the financial year 2023 from the taxes, impost rates and duties and all other revenues received by the consolidated fund. Section 7 of same act empowers the minister to limit expenditure previously authorized if a receipt of the revenue of less than anticipated. Furthermore, Section 3 of the Fiscal Management Responsibility Act number 3 of 2003 requires the government to adhere to the following objects. B. Prudent management of the financial risk faced by the government having regard to the changing economic circumstances. Under the Section 10, 11, 12, the Minister in charge of the subject finance has to inform the Parliament if there is a shortfall in estimated revenue or cash flow in the mid-year fiscal position report. Under the Article 43, read with the Article 148 of the Constitution, the Minister is responsible to Parliament which control public finance in giving effect to these laws and financial regulations. The interim order issued by several judges of Supreme Court attempts to prevent the implementation of these laws and make the control of the public finance Parliament a nullity. It is also an interference with the control of public finance parliament. It is also interference with the sacred powers vested in the Parliament respect of the control of the public finance. The interim order seeks to give effect to the activity budget estimates for the year 2023. The activity budget estimates is not a law, no a legal document. It is a summary of the appropriation bill of 2023 to assist Parliament during the debate. This interim order seeks to give legal validity to the activity budget estimates overriding an act of Parliament, the Appropriation Act number 43 of 2022. This is also an effect to prudent management of a public finance, thereby violating the provisions of the Fiscal Management Responsibility Act. Under the Constitution, the Election Commission is responsible to Parliament. The Chairman of the Election Commission has already communicated to you, Honourable Speaker, the issues faced by the Commission is respected to the local authorities election. Furthermore, a resolution has been introduced into the order paper to appoint a select committee to inquire into the holding of the said election by the Election Commission. Therefore, there are matters which have already come within the purview of the Parliament and now matters that constitute business of Parliament. The matter has brought to the notice of the court by the Attorney General's Department before the interim order was made and it appears that the honourable judges who issued the order has overlooked the same. The number of applications were filed in the Supreme Court regarding the local authority election 2023. The proceedings with respect to these applications are pending before another bench of the Supreme Court. In those proceedings, only of the issues pending determination by the Supreme Court is secretary to the Treasury's affidavit on non-availability of funds. The Council for the Election Commission has sought further time from the court to respond to the said affidavit. Similar affidavit was filed in this application. The interim order has disregarded the affidavit the contents of which is under consideration by the other bench. When one bench is Supreme Court has proceeded to disagree this fact and issue stay order, when issue a stay order, in would constitute a controversial of established practices and norms leading to the judicial anarchy. The Election Commission is not a party to the this application, SCFR application number 69/2023. The interim order has been made without any reference to the Election Commission. The interim order violates the principles of the national justice. One of the learned judges who issued the interim order is related to a petitioner in a similar case being heard before the other bench of the Supreme Court. The learned judge has not disclosed the relationship, nor has he rescued himself from this case. Honourable Speaker, I recall my memory the late Honourable Ando Bandanayaka decision over the court. Therefore, I see this is a clear breach of privilege and power of the Parliament. Please refer this to the Committee on the Parliamentary Privileges as an urgent matter. Thank you.
That will be referred to the Parliamentary Privileges Committee.